What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you guys are having a great day so far. It is Friday. We made it, end of the week. Got a 3-day weekend. Big Labor Day weekend. What are you guys all doing? What are you guys' plans for Labor Day? You guys do anything fun? I will tell you what I'm doing. I am going to play a bunch of video games with my beautiful girlfriend and probably eat some chicken wings. That's what I'm doing. And, of course, doing some court. We got to watch some court. Spent a lot of time over the last 2 or 3 days making sure I had content for Monday because, not only do we have a members-only Monday night, we also don't have any courts. So I had to make sure I had extra content ready. So hopefully we can do it. Anyways, I hope you guys had a great week. Be safe this weekend, everybody. Seriously. I know I joke and I say don't do anything dumb. I will cover you. That is true. I will. If I see you in court, I will cover you. And I'll say, ha, ha, ha. That's Nancy. That's Nancy. I know Nancy. She's in trouble. Yeah, I'm not going to do it like that, but I will do something like that. So don't do anything dumb, everybody. The police are going to be out this weekend, so just behave yourselves. Get an Uber. No reason to drink and drive. All right, let's watch some court. We start in Texas. Judge Rosie Speedlin Gonzalez. One of my favorite judges to watch, and we all know why. All right, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick back lips. Let's go.
You'll stand in front of the cart, sir.
Okay, here we go. Olga, let's open the record in case number 731995 in the matter of the state of Texas versus Mr. Patrick Golbach. Mr. Golbach, you're on live. Can you hear us?
Yes.
Have you consented? Have you given your attorney, Mr. Leslie Sakhanovich, and this court
JD
permission to go forward with your proceeding via video conference, also known as a Zoom app?
Yes.
Thank you very much, Mr. Golbach. Please stand by. Can I get announcements from the attorneys and from probation?
Jordan Sims for the state of Texas.
Leslie Sakhanovich for Mr. Goldbach.
Marie Martinez for probation.
Mr. Golbach, I do need to swear you in. Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under penalty of perjury should you make a false statement or lie to the court?
Yes.
You may put your hand down. Now, Mr. Golbach, back on the 28th of May, just a few months ago of this year of 2024, you were placed on 2 years of probation. You submitted a request to the court asking to be placed on community supervision instead of you serving time for the offense for which you were going to plea on at the Bexar County Jail. The court granted your request and placed you on community supervision for 2 years with the understanding that you would follow the court's orders and comply with your conditions of probation. At that time, the court admonished you, warned you that if you were to return to the court, because the state filed a motion to revoke your probation, alleging that you had not complied with the order or your conditions, and you're back today, that if you came back like you are today, that you could face the full range of punishment for the offense for which you were charged. The full range of punishment for the offense of a simple assault, elderly, can be up to 1 year of incarceration at the Bexar County Jail. In addition to those 365 days, Mr. Golbach, the court can fine you up to, but no more than, $4,000. And if not already done so, you could also lose your Second Amendment constitutional right to bear firearms. So we're here today, pursuant to the state filing their motion to revoke your probation, Mr. Golbach. I want to make sure you understand why you're here and the possible consequences of this hearing. Do you understand, sir?
Yes.
Thank you. Please stand by. With that, Mr. Sims, why are we here today?
On or about the 11th day of June 2024 in Bexar County, Texas, the defendant Patrick David Goldbach did then and there contact or attempt to contact Elaine Goldbach by telephone, mail, or in person in violation of condition number 22.
Is that all you're going on? Is that-
Additionally, there is one more, Your Honor.
Okay,
On or about the 16th day of June 2024 in Bexar County, Texas, the defendant, Patrick David Goldbach, did then and there possess incendiary devices on his person in violation of condition number 23.
okay. Anything else?
That is it, Your Honor.
Thank you. Okay, Mr. Goldbach, there's two allegations that the state has made that they believe render you having violated the court order that was issued on the day you were placed on probation. So that was the 28th of May. And in that court order, the judge handwrote the notes that you were prohibited from possessing incendiary devices, and there was a no contact order with Elaine Goldbach. So the state is alleging that on or about the 11th day of June of 2024, you attempted to contact Elaine Goldbach. Is that true or not true?
It's true.
Okay. And then the state is alleging that on or about the 16th day of June of 2024, that you were found in possession of incendiary devices in violation of the probation order. Is that true or not true?
That's I'm a chain smoker. I smoke cigarettes. I didn't know.
Can you read, sir?
Yes.
Did you or did you not have incendiary devices on your body on the 16th of June of 2024?
They told me I could have a lighter.
Mr. Goldbach, did you or did you not have incendiary devices on your person on the 16th day of June of 2024?
I don't believe so.
You don't believe so? So it's a not true plea on number 23. Is that clear?
Lessons. Is that true?
I'm asking you, sir. Your attorney cannot testify for you.
Yep.
Yep. What?
No, I didn't have I don't believe I had one. Who reported I had one?
Okay, Mr. Goldbach, I'm going to go ahead and say that you are stating not true because you're evidently of the mindset that a lighter is not an incendiary device.
Yeah, that's what I was told. I don't know if that's true now. Sorry.
Can you light a fire with it, Mr. Goldbach?
I believe so, yeah.
Okay, so that's an incendiary device. So did you have an incendiary device on you on the 16th day of June of 2024?
Yes.
True or not true?
True.
Okay, I'm going to change your not true to true.
All right. Yes, it was a lighter. It was a lighter. Now, there's a reason why he was charged with this, and you're going to find out. When the facts of the case come out, they were probably looking for something to just ding him with, and this is what they chose. You got to listen to the facts of the case, because right now it sounds ridiculous that he had I don't know if it was a bond or a probation violation. I don't even remember what kind of hearing this was. But right now it does sound ridiculous that he had a lighter on him and he got dinged for an incendiary device. Man, that's a harder word to say than Cheshire cat. All right. Anyways, while I paused, Tammy, thank you so much for being a member for 5 months. I appreciate it. Thank you so much. That is awesome. And Janie, my favorite Kiwi. It is really good to see you, Janie. Thank you for the super chat. I know you're always watching, Janie. I know. Tough time change, but Janie, I appreciate you. All right, let's go.
So, state, we have a true plea by Mr. Goldbach on violation number 22, and we have a true plea from Mr. Goldbach on violation number 23 as pled by the state. What is the state seeking today?
The state is seeking to revoke, Your Honor.
Okay, let's go to probation and see what probation can tell us. Officer Martinez, can you please give the court on the record the recommendation from community supervision from adult probation and a brief report? It's probably very brief in light of the fact that he was just placed on probation on May 28th. A brief report on Mr. Goldbach's compliance with the court orders overall.
Yes, Your Honor. Mr. Goldbach did just start probation. The department started receiving concerning phone calls from basically the whole neighborhood. They involved a department that is with SAPD that supervises certain neighborhoods, target neighborhoods.
They call it spotlighting.
This department received several concerning complaints about Mr. Goldbach residing with his mom against her will. She was afraid. She let him stay in a shed in the back, but he was starting fires. The neighborhood was very worried about his conduct and his erratic behavior. He was bothering neighbors. We were constantly getting phone calls from neighbors and from this department at SAPD. They said that he was a continuous threat to the community and to that neighborhood specifically. And they asked us to do something about it. And when they located him, they said he was smoking meth and had it was more than a lighter on him. It was a high-powered lighter type of device. Anyways, the department said that he's unable to pay for the GPS that you ordered because he is homeless. He also needs mental health services, but he's refusing mental health services. He says that it's his choice to take or not take medication. It's his choice to take or not receive treatment. He does not want to be on the GPS device. He states he is disabled and cannot work, but he does not want to apply for disability. He does not want to comply with probation. He does not want to submit UAs. For this reason, we have no choice but to recommend revocation for the safety of his mother and for the community that he keeps tormenting.
Thank you. Mr. Sakhnovich, anything you want to add to the record or any argument you want to present to the court?
No, Your Honor, I don't have anything.
Thank you, Mr. Sakhnovich. Mr. Goldbach, you're right. You have every right to refuse medication. You have every right to do whatever you want. But then I have every right to keep the community safe from you and individuals like you and your mother from you. So today, the court is accepting your true pleas on violations of condition number 22 and condition number 23 as pled by the state. The court is granting the state's motion to revoke your probation, Mr. Goldbach, and the court is sentencing you to 365 days at the Bexar County Jail, 0 fine. And Ms. Martinez, how many days does he have at the Bexar County Jail?
85.
85. The court will give you credit for 85 days served. You still have almost 200 and almost 300 days left to serve. Mr. Goldbach, you're going to stay at the jail and serve that time. You go ahead and make your choices there and see how far that gets you. No, I'm not hearing from you anymore. Your second chance was granting your probation request. I'm not going to argue with someone who's mentally ill and drug addicted. That'll get us nowhere. But I will protect this community from someone who has mental health issues and is drug addicted. Good luck to you, sir. That concludes today's proceeding. Everyone is excused.
Yeah, I told you. I feel like they were just trying to find something to ding him on. Those were some scary allegations. So good job, Judge. Go, Judge Gonzalez. All right. Next one. I just skimmed through this video right before I started and I already forgot. Hold on. I got to do the play for 2 seconds and then see if I need to preempt the video. Yes. This one. You know what? I'm not going to preempt this video at all. All I'm going to say is this defendant refuses to talk. That's all I'm going to say. If I preempt this video, it's going to spoil what happens. All right, let's go.
It's a Thursday. Is that Brett as well?
Yeah, Thursday makes more sense to me, and that is Brett as well.
Yeah. Okay. Is this Mr. Karpinski?
Correct, I think.
All right, so we're gonna go in a breakout room so you and I can talk. I'm gonna be your attorney representing you. So, do you know how to do that? If you look on the computer screen, you should have an option for enter a breakout room. Can you hear me okay? Do you want to ask the corrections officer to come in? No. Well,
we could just set him over.
When was he?
If he's not going to talk to counsel, there's not much we can do with him. We'll set him over. He can wait till tomorrow.
Did you want to speak with me so we can talk about your case a little bit, sir? Okay.
All right, just a quick landscape. Obviously, the defendant top left. He's He's standing mute. You know, some people don't know how to do this. He just does it a little too well. Defense attorney's top right, prosecutor's bottom left. The judge is the bottom right. The judge is on mute and doesn't know it. And the defense attorney and the prosecutor are having this conversation. The judge has no idea he's on mute. So just another little layer of humor going on in this court right now. Everyone's confused.
Would love to be able to assess his competency. But yeah, if the corrections officer can come in. I'm just gonna check my notes to see when he was booked. 8/24.
If he's not cooperative, then we can just set him over till the next day. I mean, he's had his shot, he's here, he's had a chance. We'll bring him back tomorrow and see if he understands his chance better tomorrow.
I guess we can address probable cause. And
Do it.
okay.
Yeah, that's very important. Very important. Go take care of that. We do not need your shelter to be attacked by super mutants. I mean, this is important stuff we're talking about. Also, the judge in the bottom right, he's a pro tem judge just for this day. He is normally an attorney, which is why his label is whatever it says, which is funny because it was like the docket right after this, he wasn't a judge and he was an attorney. I don't know how that works. Just a random attorney just as a pro tem judge and then goes right back to being an attorney. That's kind of weird to me. But, you know, I guess they make it work. Judges take vacations too and sick days.
So this is cause number 24L001448, Daniel Karpinski, on an arraignment for 1 count of reckless driving. We're asking the court to appoint based on his in custody status. We'll waive a formal reading based on my review of the police report. Will stipulate to probable cause. I have not had an ability to speak with Mr. Karpinski, so we're asking that he be brought in tomorrow if court is finding probable cause and holding him.
Your Honor, you're muted if you were trying to talk to us.
I was. So I found probable cause, and you're just asking me to set this on the arraignment calendar tomorrow morning?
Correct, Your Honor.
Okay. And can the clerks tell me, is it the WSH arraignment or the regular arraignment, the 8:30 or the 9 o'clock?
Well, he's in Nisqually right now, so I would say the 9 o'clock.
It should be the 10 o'clock Nisqually.
Or 10 o'clock, yeah. That's, and the court just
Perfect.
weighed in on that, yes.
Yes, they did, right before I clicked on the button. Wrongly. Okay. Okay, sir, I'm setting this over to August 27th at, it still says 9 o'clock. Hold on. It's for some reason not letting me set it over to 10 o'clock. It's
Look at that face. I paused at the perfect time. Or the worst time, because I was actually going to hope that he jump scared everybody, and I was just going to pause it and say, everyone pay attention to the guy. Yeah, I ruined that jump scare. Hold on. I'm going to rewind it 5 seconds and pretend I didn't just pause it.
9 o'clock. Hold on. It's for some reason not letting me set it over to 10 o'clock. It's defaulting to. Okay. Well, good. He's removed himself. Okay. So I'm ordering this to be at 10 o'clock. The order's not letting me do that. It's making.
But at least that means he's being in contact with him.
And I was muted the entire time I was talking. I was muted. We're making fun of Judge for being muted, and I was muted. All right, this is the next day. You know what? That's all I'm going to say. It's the next day. I don't have to rehash what I just said.
All right, ma'am. It looks like Mr. Deal is doing what he needs to do. He's complying with court orders. He's keeping in touch. He's enrolled in his MRT program, so that is all in his favor. And so based on that and combined with the fact of what the information you've provided me today, I will grant your motion to recall the no contact order. You'll want to keep this document on your person just for a little while, just to make sure, because they have to enter into the system to recall the order. So just to be on the safe side, just keep a copy of this order. We'll give that to you today. And I'm sorry about your diagnosis, but I hope everything goes well for you.
Thank you. Now I get Colin.
All right, that's it. You can get that document from the clerk.
No, this is the case before. I think it was in person, so they're not on Zoom. I don't know, but I had it cut a little early because he's dancing, he's jumping all around. He's not just acting like a 5-year-old and like I'm not gonna talk. He still doesn't really act right, but he at least talks today. But I wanted to show you his attitude today. Yeah, I'm saying today a lot. Okay, let's go.
And then you're all done. Thank you, ma'am.
Sure. You're okay. You're okay.
Just come right up here and she'll give you that document.
And you're already on Mr. Karpinski.
Okay, let me get back there. All right, this is cause number 24L001448. We're here for arraignment. Go ahead, counsel.
And that is correct, Your Honor. For the record, Luis Carla for Mr. Karpinski. We're here on arraignment on one count of reckless driving. We will acknowledge receipt of the complaint, waive any further formal reading, and ask the court to enter a plea of not guilty on Mr. Karpinski's behalf. He does qualify for the public defender, so we do ask that Horwath Law be appointed to represent him in this cause, and we will stipulate to probable cause for purposes of establishing conditions of release.
Right. Mr. Karpinski, sorry, did you go over the rights at arraignment with the attorney today? Oh, he's muted.
Uh-oh.
1 second, we'll unmute you.
Yes, I did.
And do you have any questions? Do you have any questions about those rights, sir? You can go ahead and sit down.
No, ma'am, I just want to be released today.
Okay, that was my question. Did you have any, have any questions about the rights?
Oh, no, I don't. I just want to play coin top game when I get out and talk to my friend.
Okay, sir, one thing at a time.
Okay.
Okay, hold on. I'll accept the stipulation of probable cause. We'll enter a plea of not guilty. And I will hear from the city.
Your Honor, city won't object to release a defendant on personal recognizance.
Heather, I don't know if you're still here, but the defendant says he wants to be released today so he can go play games with his buddy. I mean, it kind of fit perfectly. You're playing games. He wants to come play games with his buddy.
I would ask that the court order the defendant to maintain law-abiding behavior, appear at hearings, notify the court if there's any change in address. Do not operate a motor vehicle without a valid license and insurance. Thank you.
And no objection from defense. Mr. Karpinski's already done 3 days in custody.
All right, sir, I am going to release you on your personal recognizance today, but there are conditions that I'm going to impose The first being that you must appear timely at all future court hearings. Your next court date is September 24th, 2024 at 1 p.m. here at Lakewood Municipal Court. You must appear in person for that court date. If you fail to appear for that court date, the court will issue a warrant for your arrest. Understand?
Yes, Your Honor.
Okay, the remaining conditions are that you have no criminal law violations. You must keep your address updated with the court and Department of Licensing, and you may not drive a motor vehicle without valid license and proof of insurance. Any questions about those conditions, sir?
Yes, may I drive my truck to my friend's house, and if I don't drive recklessly?
If you have a license and insurance, is that you have to have a license and insurance in order to drive.
So as of today, is it my license gonna be suspended, but I can still drive, or is like?
Sir, I would.
Yeah, you're gonna have to talk to your attorney about that. I have made a direct appointment, so you'll get your attorney's contact information. If you have questions about your driving status, I would suggest that you call them before you do anything. But my condition is that you're not allowed to drive without a valid license and insurance, okay?
Sounds good, thank you.
All right, sir, so we'll see you on September 24th.
Yes, we will.
All right, perfect. Good luck, sir.
Good luck. Good luck. Going to game. My password is DGK123149. Jack me, I'm so rich.
Mr. Karpinski, you can let the officers know that you're free to go.
Thanks, man. I'll talk to you later, or hopefully not too long, but yeah.
That's correct.
What's up, guys? I'm free to go today.
And I believe that concludes the Nisqually calendar.
I don't even know what to say. The main point I want to say is they said he was in jail for 3, maybe 4 days, and he refused to talk. The second he talks, they let him go. Just saying. Just saying. Yeah, he gets to go play games with his buddies. Hopefully he doesn't drive. I don't think that guy should be behind the wheel. All right, I'm going to stop judging him. But he's getting released today. Woo! All right, next, we got to go. We got to move on. I'm going to say something. I'm going to get myself in trouble. We got to move on. We're moving on. Why did I have to put, I should have put this one after the last one. All right, I'm going to put my foot in my mouth. I'm going to get myself in trouble tonight.
All right, Mr. Wicks, do you have an email address?
What is that?
Do you have an email address?
No.
Okay. How about a phone number?
Phone number 928 951 68.
97? All right. The state is alleging 4 charges against you.
Last night.
The charges are listed as follows. Give me a moment here. First off is disorderly conduct. The second charge is driving on a suspended license or revoked license. The third is drug paraphernalia possession or use. And the final charge is dangerous drug possession or use. On those charges, you have the right to remain silent, right to counsel, and right to trial. I've scheduled you for a 2-part hearing on September 9th at 4:00 p.m. The first part of it is regarding the felony charges. That's called a preliminary hearing. And that's where the prosecutor will present testimony and evidence to a judge or to a grand jury to determine if there's probable cause to charge you with those felonies. Not convict you, just to charge you. If there is...
Hey, Bill, great to see you. Thank you for the information. Bill, I really wanted to say this to you the other night because I know when you typed in an address, one of my mods removed it, and I asked them to do that. I know you do that in Big and Chat, and that's fine. I am absolutely terrified of getting in trouble on YouTube again, and it's probably okay, but it's just something that I'm terrified about. So no hard feelings on that, and I love how you can instantly find where these people are and give that information. But I just don't like the addresses being thrown in the chat. So again, I'm probably being paranoid, but I feel like I've earned the right to be paranoid after losing my channel for 3 months. So hopefully no hard feelings, Bill. I love it when you're here.
Probable cause, that portion of the case will bind over to the Gila County Superior Court. If there's not probable cause, the felony portion of the case will dismiss. Regarding the misdemeanors, at the same date and time, you need to be prepared to plead either guilty, not guilty, or no contest to the 2 misdemeanor violations. Again, driving suspended and disorderly conduct. Depending on how you please will be what happens next with the court proceeding, and all of those options will be explained to you prior to you giving your plea, as well as the penalty ranges of those charges. Regarding your bond, I'm placing a total of $3,200 bond, and I'll break down the amounts. The dangerous drug possession is a $1,500 bond. The drug paraphernalia possession is a $700 bond, and then two $500 bonds on the misdemeanors. So since you're held in custody, sir, on the felonies, you have the right to a court-appointed attorney if you cannot afford to hire one. Can you afford to hire an attorney?
No.
Okay, so I need to ask you some.
Yeah, no, that's fine. City and state's fine. Like what he just did, absolutely perfect. Absolutely perfect. Just when the whole address is posted, even if it's in the chat, I don't know how YouTube scans the chat, but they do sometimes. And again, just paranoid about it. But yeah, just minimal things, city, state. Yeah, that's fine. Again, what he just posted was perfect.
Questions about your finances to qualify you for a court-appointed attorney. If you would raise your right hand so I could administer an oath. Do you solemnly swear the information you're providing the court regarding your finances to be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. What is your marital status? Single, married, partnered, separated, or divorced?
She passed away.
Okay. Do you how many other people do you financially support?
Beside myself, one.
One other person?
Yes, sir.
Okay. And what is the age and gender of that other person?
Male, and I think he's over 61.
61 male?
Yes.
Does he live with you?
Yeah.
Okay. Do you have a job?
No, I'm disabled.
Okay. Do you receive any disability income?
So the Social Security disability.
Social Security disability?
Yes, sir.
Okay. Do you have any other take-home pay sources besides that?
No.
Okay. How much is that disability Social Security income?
It's not enough for a lawyer.
Okay. What do you get about a month?
I think it's $1,300.
Okay. Do you own a house?
Well, that depends on if I gotta fight this lawyer. I've only been living and bought that.
Do you currently own the house?
Well, it's my house with my wife, but I gotta fight her brother. He's already stolen two homes, and when he comes here, he's gonna be doing it trying it for the third time, and I'm defending that place. Nobody's getting in.
Okay. Do you have any bank or retirement accounts?
No.
Okay. Do you have any outstanding loans?
No.
Okay. What are your monthly expenses approximately? Here's an easier way to figure it. You get about $1,300 a month. How much at the end of the month of that is free spending money?
None.
So your expenses are about all $1,300?
Yeah.
Okay.
To you, Army, I have no problem being in
All right.
court. And the 2 officers assaulted me on my own home.
Okay.
I wasn't even in the car.
Sir, you do qualify for a court-appointed attorney, so I'm going to assign that attorney to you. The way that works is that attorney will be assigned, so you're held in custody, and
Come on. Come on. I mean, you assaulted me on my own property.
Do you want me to explain? Do you want me to explain further the process? All right, sir. So since you're in custody on a felony, the count.
I have not even done that. I wasn't even in the car.
the county attorney has 48 hours to file a complaint against you. If they don't do that, regarding the felonies, you'll be released on your own recognizance without having to post the bond.
Could you please release me on my own recognizance?
I cannot, sir. So, the 3,200 will remain in place, and we'll have to see how the county attorney files a complaint about
This is ridiculous.
it. Okay, that'll be all, guys.
Johnny, come on. That's bullshit. I don't want to see. Get me out.
Apologize, sir. He's probably gonna be yelling over the court.
Yeah, he yells for about the first 2 or 3 minutes of the next person's hearing. Yeah, wasn't gonna make you guys sit through that. All right, yeah, I'm not gonna comment. Not gonna comment. I like why is Biggin in jail? That's funny. They arrested Santa. I see where you guys are coming from. See, and I'm gonna keep it at that. I don't want to get myself in trouble. What do we have next? Okay, this one, unfortunately, the first 3 or 4 minutes of this, the judge had it on mute, but it heats up. We jump into it being heated, but we didn't see what happened to get us here, and I apologize. I could have played the first 3-4 minutes on mute, so I just cut them out instead. I don't know, but yeah, but it's kind of funny. And when I was listening to him talk, when it came off mute, I thought he was a sovereign citizen, and you're going to hear exactly why.
Oh, that's what I was saying. So, as part of the trust, though, the trust does not pay me a salary or an income rate. I'm basically doing it voluntarily. I guess I'll say voluntarily. I do not charge, as the trustee, property manager, landlord. I do not charge the trust because the trust provides the expenses. Now, this is an irrevocable trust. This is not an expense the irrevocable trust would cover.
I have no idea because you haven't presented the trust to me.
So a trust.
I know what a trust is, and there's a
Correct.
trust document.
Correct.
Which would say what they would and would not pay, who the beneficiary
Correct.
is,
So-
who's the trustee.
Yes,
You
sir.
have not presented that.
Yes, sir. So as the trustee, I'm the only one who can interpret the trust. Secondly, a trust is a private document. A trust.
The only person who can interpret the trust,
Correct. That's the
That's-
definition of the trustee.
that's absurd.
That's
The court of
definition.
law can interpret the trust.
They can, but again, so in this case, though, the court would not have standing. A trust document is private. It's not a will, which is public. So for those reasons, it can't be produced. This
And
is
Mr.
not a
Asper,
probate case.
You have 30 days to make a payment or present the documentation to the court, or you are in contempt, and I will sentence you to jail until you comply.
How long are we-
Understand?
How long are we talking?
What do you mean?
How
How
long?
long?
Oh, you said until I comply. That's
Until you comply. That is civil contempt.
Civil contempt, yeah.
Where I can hold you in jail until you comply with the order of the court. You are ordered within the next 30 days to either make a payment or present the documentation that you keep referencing and never presenting, or I will hold you in contempt of court until you comply.
What is the current balance?
400, I just wrote it down. $495.
So how much credit would I get per day?
For jail? You
Correct.
don't get civil contempt, you don't get credit against your fine.
That's what I thought. Okay. All right. It's criminal, yeah. Okay. As far as the People versus Vanderpool case, so that was one
I
specific
just
thing.
ruled that that doesn't apply to your circumstances. If you decide you want to provide some other law between now and then for me to consider, I will happily look at it. But this is not a probation violation. Vanderpool does not apply.
Well, so on this, it does say, well, this would be a violation of something, because.
It is a violation of a court order to make payment on your fines and costs. That is how it is contempt. That is why this is a contempt show cause.
I understand that. So in that Vanderpool case, though, one of the things was as well as time to pay his court-ordered fines and fees. Since he was terminated from probation, he was no longer required to.
That's why this is contempt, and it has a maximum possible penalty of up to 93 days in jail as a criminal contempt versus a probation violation where he's on probation for a 5-year felony. He could go to prison for 5 years. That's the difference. If it was a probation violation, he could have gone to prison for not paying. After your probation is over, the court still maintains jurisdiction to collect fines and costs. And if you don't follow the court order to pay, it is contempt.
This was after he was terminated from probation, which is.
They said they had no, I'm looking at, because
Correct.
the trial court was without authority to extend defendant's probation, we reversed the judgment of the Court of Appeals and remand to the circuit court for further proceedings. They could not extend his probation. That does not mean that they can't order him to pay already due fines and costs.
Fines and, I'm not trying to argue.
Mr. Asper, you are, and I've made my ruling, and I've told you what my ruling is. So I will put it into a written order, and you can comply or you cannot comply. You understand the consequences of that. If you want to appeal my ruling to the circuit court, you are welcome to do that as well.
And that's, yeah, I'm not gonna do that. It's a waste of time. The transcripts would cost just as much. Okay, thank you, Your Honor. Have a great day.
All right, so we're gonna give you a court date for 30 days because that's the 30 days till you either make a payment or present these documents that you like to reference, your trust documents, etc. And if you don't, then there will be civil contempt until you comply.
Before we leave today, so if the payment is made before that, does that cancel the hearing?
Then probably put it out another 30 days to see if there's another payment or not.
No.
If you're paid in
when
full,
I say
we will,
clear out.
yeah, if you pay in full, we're done, we close the file, we stop talking. If you pay a partial payment, then I will adjourn the hearing another 30 days to see if we continue to have issues with payment or presentation of documents.
Okay.
Okay?
Yeah.
Okay.
While we don't agree on this, I will agree to your order. As far as the trust document goes, though, as I stated, that's a private issue that would only the beneficiaries and heirs have standing to demand the trust document. And it's actually for a judge, prosecutor, attorney, for anyone to ask, I don't have the case law on it, to ask for the trust documentation, which obviously this isn't going to happen here, but that can result in fees and fines against that person. And that's in the, I can't remember the cases. No worries, Your Honor. I understand.
Okay, you got your court notice, your excuse. Have a good day.
Yeah, it's a real shame that we didn't see the first couple minutes of that. Is it possible that he's a sovereign citizen? We don't even know what the case is about. He owes court costs and he's talking about a trust and the court can't see it. It's a private trust. Yeah, I don't know. I really want to see the first 3 minutes, but it's muted, so it doesn't matter. Jedi. Sorry, 2 a.m. Sith. Thank you so much for the Venmo. I appreciate it. Thank you. Very generous of you. Thank you so much. All right, next case. 2 a.m. Sith. Weirdo. Whoever gave me that name is a weirdo too.
All right.
All right, Judge Middleton. This one, my channel is a little over a year old now, and I have seen her 4 or 5 times. And the reason I know this is because her first name is September. And every time the judge usually makes a joke. He doesn't right now. Well, maybe he does. Because he does say something about he can't believe it's the end of August. But that might have been, I don't know. That might not have been this case that he said that. Anyways, Judge Middleton, let's go. This lady is just a mess.
We are back. We have a couple of bench warrant arraignments to address. And we're going to do that now. With us is the Chief Public Defender, Mr. Keith Stickley, and also, is that Amanda? Ms. Hutchinson, can you hear me? Can you hear me? They're at the jail? Good morning. This is Judge Middleton. Can you hear me? Oh, that's September.
Yeah.
All right. Good morning.
Good morning.
This is file number 241397. People versus September Knowles. This original charge is assault and battery and disorderly person. Your attorney is Mr. Tim George, and he's not available this morning. With us is.
Yeah, it only takes about 2 seconds to get dinged. That's all it takes for a song to ding you for it, and they will instantly ding you, which is weird. I know I could play it and then go back and edit it out, and I might be fine, but again, paranoia over here. Not gonna try it.
Mr. Chief Keith Stickley, the Chief Public Defender.
Okay.
All right, plea has been entered. Okay. Ms. Knowles, Judge Pattison was handling this case. He's not here. So I'm covering today, and I've known you since you were 18, probably.
Yes, I would just like to fully explain. I would like to fully explain so you understand that I was not trying to cause any problems. I was trying to get a justice.
All right, well, I don't believe you were, but let's back up. You got charged with assault and battery and being a disorderly person. You pled no contest to, I think, disorderly person. Judge Pattison reduced the bond to a PR bond of $2,000 and set the matter for sentencing at least 10 days out. So it was set for sentencing on September 17th at 10 a.m. with your lawyer, Mr. George. Judge Pattison issued an order that you not consume any alcohol. And I'm not telling you any secret. You and I've had this discussion before. I am worried about your well-being. You are in such dire straits that I'm afraid we're going to find you dead one morning in a ditch someplace. Anyway, there was a condition of your bond that you not use any alcohol. And you got arrested last night at the Nottawa golf course. And according to the police report, your blood alcohol was 0.20, which would violate the condition of your bond. And several of these other cases, you've been at some place where you weren't wanted, a house, Pizza Hut, an apartment, when you were intoxicated.
Everything was stolen from me, Your Honor. And I literally, I have a good job. I just needed, all I was trying to do was get established. And I didn't have my medicine. So I was trying to get a destination to be able to go get my medicine because I made responsible appointments. And I do not want to consume alcohol, Judge Middleton, I do not. But I have epilepsy, I have an ulcer, I also have severe panic disorder and high blood pressure. So I did not have my medication, and I have help, and if keeping me detained is not going to help me, I need to get out and make these appointments so I don't drink alcohol and so I don't come back here. I tried explaining to these officers that
let me just ask a question. Mr. Stickley, you can decide whether you let her answer it or not. How'd you get to the golf course? Is that okay if she answers that? We can't hear you, Mr. Stickley.
You can't hear me?
I can hear you now. Now I can't hear you. You sound worse than Charlie Brown's teacher.
Can you hear me?
No. You need to speak, I guess, right at the microphone. No, that's worse.
Tech is hard, right? Tech. So hard. So hard. All right. We got about 2 seconds before he jumps back up. So while this is a good time to pause, Mayor, thank you so much for the hell of it. I appreciate it, Mayor. Thank you so much for the super chat and the 5 gifted memberships. You are awesome, Mayor. I appreciate it. Welcome to the 5 new members. Also, Wixom with the 5 gifted memberships. Thank you so much, Wixom. You're awesome. And Cheshire Cat. Cheshire Cat. Thank you all for the gifted memberships. Welcome to the 11 new members. You guys are awesome. All right. I feel like I gotta take a deep breath after I attempt to say Cheshire Cat. Okay, let's go. Cheshire Cat. Cheshire. Okay, we're just going. We're just gonna go.
Try again.
Practicing. I've been practicing.
Can you hear me now?
Yes, much better.
Okay. Ms. Knowles, I would advise you right now, not knowing what's going on in the previous cases, not to answer anything that would potentially incriminate you. Are you set for sentencing?
She is set for sentencing for, I just had it up, September 17th. That's farther out than I would like. She's set for sentencing for September 17th at 10 a.m.
With all due respect, Your Honor, my advice to her would be not to make any additional statements because there's information that I don't know about and information that I don't want her to put on the record that might make the situation worse.
The officer told me that he said that I was cooperating. I wasn't going to get in any trouble.
Well,
I did everything I was asked.
We don't.
And
all right.
I got transportation, but they couldn't take me the whole way. So I ended up walking because I have to have my medicine. I don't want to keep on getting.
I think this is a safe question. Ms. Knowles, where are you living right now?
I'm living right in Centerville, across the street from my father. If I could please get out so I can please try to get my medicine. He was working. I had things I had to do.
All right. Well, lives in Centerville where?
Right at the corner.
Sir, please. Every time you open your pie hole, you get it worse troubled. So stay the course, will you?
All right. Didn't they ask you to leave that place?
No, he dropped that, and I was right by there. I'm just trying to get somewhere. I was just trying to get to a doctor's appointment, and so I could call a family member or something. I didn't have anything with me. I don't need to be in jail. If you can believe that.
Let me stop you for a minute. Let me stop you for a minute. I'm gonna you do need to be in jail. You're killing yourself. You're drunk, you're staggering around, you're at a golf course and the people are concerned about who is this intoxicated lady. You're on a special bond condition that you're not to drink. Stop.
Okay.
I'm gonna let Judge Pattison deal with this. Right now, I'm gonna cancel your bond.
When can Tim George come see me?
Well, I'm gonna see Mr. George at lunchtime and I will tell him that you were there. I'm gonna
Can you
cancel your
please have him,
bond.
can you please have him come down?
Yeah, I'll ask him.
Because sir, I was offered a job at that golf course. A gentleman by the name of Don that is running that golf course offered me a job, and then I was waiting for this guy to get done golfing, and
All right, well,
he said
let me stop you. He's the one that called the police. So there is no job waiting for you at Nottawa Golf Course.
he offered me a job. I have the phone.
They probably revoked it because you showed up drunk there last night. So I will tell Mr. George that you're in custody. I'll see him in a bit. And I will talk to Judge Pattison when he gets back on Tuesday. Right now, you're not presumed to be innocent. You have entered a plea of guilty. You've been in this rock bottom pattern for the last 2 years or more. And I'm serious. I'm concerned that you're just not gonna be here.
Yeah, we confirmed it. Unless he said it to somebody, then no, he's on the bench, or his current term is till 2026, or the end of 2026, like December 31st of 2026 is his last day on his current term. So unless he announced it specifically to retire early, yeah, I mean that's how I confirmed it. Also, BSBT, man, be careful. This is your warning, man. This is your warning. I like you being here, BSBT. You bring a little spunk to the chat, but we're not gonna be fighting with each other in the chat.
So, all right.
I don't want to drink, Jeff, or
I know you don't, but you can't. I don't know the answer. So right now, you're free to go. I will talk to Mr. George at lunchtime. Your bond's canceled. It's set for sentencing for September 17th unless the matter gets moved up. All right, we'll leave her in the waiting room.
All right. I actually think we might be going to the last case of the evening. All right, let's see. Oh, he's already gone. He came in, said two things, and left. Is it the last one? I didn't think this one was that long. Let's see. I don't think this one's 20 minutes long, so there might be one more after this. Anyways, Judge Shackelford. I wish BSBT was still here. This is his best friend. This is who's looking for him currently.
4012602 Jesse Brown versus State Farm and James Huff. Mr. Brown, can you turn on your camera, please?
Yes, I'm here.
Okay, can you turn on your camera?
Let's see how to do that. Okay. Can you hear me now?
Yes. I can, yeah, I mean, it's a black screen, but I can see that you're there.
Yeah, I got a black screen as well, Your Honor.
All right, so I'm looking, because this case was
But I can
small
hear you.
claims. Okay.
This is absolutely the person that scared him so much that he requested a jury trial and then didn't show up. Yep, this is absolutely that judge. What's up, K-Bar? Good to see you, bud. Good to see you.
Okay, can I get everyone's appearances?
Oh, and real quick, Erica, you have nothing to apologize for. Nothing to apologize for. I saw you said sorry. Yeah, don't worry about it. It's not your fault. He likes to just jump in, drop a couple lines, and then get kicked out. I think he just enjoys that. That's his Friday night fun.
Good morning, Your Honor. This is Courtney Fields on behalf of Defendant State Farm.
Good morning, Your Honor. This is Taylor on behalf of Defendant Huff.
All right, and Mr. Brown, can you tell me your name? There you are.
My name is Jesse Brown.
Okay, so this matter was originally a small claims case. And it was,
Yes.
There was a judgment received. There was an error with respect to that because the defense attorney had actually emailed the court an answer. So since it was filed timely, there was no default judgment. And now we're here because the case has been removed from small claims and has been taken into general civil cases, which is something that either party can do, Mr. Brown. So this is the first time we're all meeting in court. I have Mr. Brown here. I have an attorney for State Farm, and then Ms. Fields, you are, I'm sorry, Mr. Arndt, you're here for James Huff. Is that correct?
Correct, Your Honor.
Would the three of you like a breakout room to have discussions?
That's fine, Your Honor.
What, is that okay with everyone? Do you want to have a discussion before we go on the record and I set a scheduling order?
That would be fine, Your Honor. State Farm was erroneously listed as a defendant in this suit, so we actually need to be let out. I don't know if that's something Mr. Brown is, I know that he's in pro per and, I certainly don't want to confuse him, but according to the statute, State Farm has no business in this suit because we're not a person under, 500.3135. Mini torts are where a person remains subject for tort liability. State Farm was not a person. We don't own or maintain or use any vehicles. We weren't involved in this accident. So Mr. Huff should be the sole defendant in this suit. We were erroneously named and we need to be let out.
Okay. Were you Mr. Huff's insurer?
I believe so.
That's true.
Okay.
I'm covering for the attorney of record, but I believe that's how we got involved. Yes.
That's correct.
That's correct, Mr. Arndt?
It is, Your Honor.
And is everybody in agreement that State Farm should be let out since they weren't the owner of the vehicle and it's a mini tort claim?
No, ma'am. No, Your Honor.
Okay. Okay, why not, Mr. Brown?
Well, Your Honor, I was rear-ended and I wasn't trying to sue for any type of pain or suffering, anything like that. The only thing I was referring to is the damages to my vehicle. For some apparent reason, this guy cut me off and ran into the back of my car almost deliberately, speeding. Okay, and I don't think that that's fair to me that he keep going back and forth to court and they don't show up to court and then they be let out scot-free. That's not fair to me. And he tore up my vehicle. No, ma'am, I don't think that's fair.
But if the insurance carrier, if he doesn't have coverage for that, then it wouldn't be, your suit would not be against State Farm. Your suit would be against him.
That's what I tried to do. That's what I tried to do.
His attorney's still here. Mr. Huff's attorney is present. So it's not that you don't have a claim, it's that the party to the claim is Mr. Huff directly. So State Farm will be excused from the case, or case against State Farm is dismissed. They're not a proper party. But Mr. Arndt and Mr. Brown, would the two of you like to have a discussion?
Might I suggest that?
Yes, this is the 23rd District Court in Taylor, Michigan. Also, I forgot to shout out Vic. Vic, thank you so much for the gifted membership. I appreciate it, and welcome to the new member, Vic. Thank you so much. Thank you so much, Vic. I appreciate it. All right. Yeah, so what's going on here is well, it's not the defendant. It's the guy on the bottom right. He filed this lawsuit against the driver and the State Farm insurance company. He got into an accident. He was originally cited for the fault of the accident. The guy, Mr. Brown, took it to court, and the case was dropped. I don't know why. They didn't find him at fault for the accident, and they dropped it. So now he's turning around and suing for the damages from the accident. So that's why he brought in State Farm, and he's suing the other driver. State Farm is top right. The other driver's attorney is on the bottom right next to Mr. Brown. So that's what's going on here. And he's just confused of what's going on.
Your Honor, we simply set this matter with respect to the procedural.
You absolutely knew that I was looking for that word. Thank you so much. No.
dates by which this case will proceed, and I think it's appropriate to bring appropriate motions before the court. I don't know that we'll get anywhere with the informal discussions based upon what's been portrayed here this morning.
Okay, well, I mean, seems like it's fairly cut and dry, right? If it's a mini tort case and someone was at fault causing the accident.
Yeah, except there are two different versions of the events of the accident, which I don't think have been properly portrayed here today. And I don't think this is the proper place to present it, but.
All right, are there police reports? Was that, hold on, Mr. Brown, we're getting there. I know you're not an attorney, sir. I'm trying to, but I have to understand certain facts, okay? Mr. Art, was there a police report?
Yes, ma'am.
Yes, Your Honor, there was.
Was anyone cited?
Mr. Brown was cited for failure to yield.
Mr. Brown, did you receive a ticket at that occasion?
Yes, I did. And I went to court and the case was dismissed.
Okay. All right, we're going to set a scheduling order then. And what that means, Mr. Brown, is you're at court, we have court dates. And there will be a couple different dates that you'll need to follow so that this case can go forward.
Yes, ma'am.
So the proper party is James Huff, who has counsel. We're going to set some dates. Discovery is going to be a
Yeah, I believe I said, well, originally I said that there's a battleground in Michigan and in Washington, and I'm not sure which one it is. That every time I say battleground, most people tell me it's in Michigan. Just because more people watch my channel from Michigan, I feel like, oh yeah, battleground's in Michigan. And we found out that it's actually in Washington. So I feel like I said that. If I said battleground Michigan, it's just because I'm used to repeating that. But yeah, no, I know it's in Washington now. The battleground court's in Washington. Got it.
limited. It doesn't sound like there's much to discover.
No, his next hearing is, hold on. It's September 27th is his next hearing. So maybe they let him out. I didn't see his bond, or if he got bonded out. I didn't see that. But his next actual hearing for the case that he's on is September 27th. So we got a little bit for his next case. Sorry, I had to pull it up in my notes to see when his next date is.
But I will give you some time. Today is
But KFAR. So we're gonna have him on 9/27, and then we're gonna have Eric Martin on 9/30. For everyone that I did tell everyone that Eric Martin was due back in court today. I can't read apparently because it was 9:30, not 8:30. So it wasn't today. It's a month from now. So I'm really sorry, everybody. Yeah, I sent Judge Slavin a message this morning, and I told him, take deep breaths. You have Eric Martin today. He's like, no, I don't. I'm like, yeah, you do. I just looked it up. And then I went back and I looked up the docket. Like, yeah, no, it says 9:30, not 8:30. Okay, let's finish this up.
August 29th. We'll do discovery until September 19th of 24. Discovery means, Mr. Brown, that you and Mr. Arndt will exchange documents. If you have any documents, you might want insurance paperwork. You might want insurance paperwork from him. You two might want to see if anyone else, I can't even imagine what you two need to discover, but I'm giving you until 9/19.
Me either, ma'am.
Well,
yes,
if one of you was
understand
cited,
that.
even if it
Go
was
ahead.
dismissed, I mean, it sounds to me like there's a possibility of a defense. That's why I asked those questions. And that's why I'm setting the settlement conference and some dates. So September 19th of 2024, all discovery is complete. Any discovery motions must be filed before that date. There will be no request to admits.
Okay, can you explain that to me, Your Honor?
I'm saying that you two can hand each other documents. You can hand each other, they're called interrogatories, they're questions. He'll send you a list of questions. You can send him a list of questions, and each party has to answer each other's questions. If one of you don't answer the other one's questions, and that person has to file a motion saying that that person's not complying with my order. So you answer each other's questions. Okay. You cannot do requests to admit. And those are just questions. If you don't answer them within a time frame allowed by the court rule, they're deemed admitted, and I'm not doing it. Witness lists are to be exchanged by 9 26, 24. So if you have any witnesses, write them down and submit that. If you have a motion for summary disposition, a motion that basically says there's no issue at law to go in front of a judge or jury for a trial, those motions must be filed by 10/3 of 24. Answers to those motions are due by 10/17 of 24. Any adjournments, agreements, stipulations must be done by tendering a signed stipulation and proposed order to this court. And dispositive motions and the settlement conference will be held on
October 24th or November 7th?
November 7th is not good. Is that wait, I'm back that day. November 7th. All right, we'll come back on. That's my first day back.
November 21st then?
We'll return to court on, I'll just do November 7th. Okay. November 7th of 2024.
8:45, Your Honor.
Yeah,
Well,
Your Honor, may I say something?
Yes,
Please.
sir.
Yes, ma'am. I'm not an attorney and I don't understand any of this. I really don't. I've been to court with these people for 4 or 5 times and I did everything I'm supposed to do. And every time I've been to court, neither one of them showed up to court. And the last time I had to file a default judgment. And all of a sudden, after I did that, 2 or 3 weeks later, I get another court date. Now I got to go to court again and again. I don't understand this. I don't.
Sir, there was an issue with the filing that came in. And that filing came in on 5/31. And that filing was the answer, and it had been timely filed. So the default could not be entered because an appearance and a answer had been filed with the court. So they responded to the court in a timely fashion. So I can't issue a default when they've done what they're supposed to do. They're supposed
But
to
I
appear.
did what the court told me to do. I did what the court told me to do. They told me when they didn't show up, the court told me, the clerk told me to come down there, file the default judgment, which I did. And it was 2 or 3 weeks later, then I get a court date. That don't make sense to me.
Well, I've explained, sir, that it was the clerk, we received the filing. And if the clerk told you that it was an error, because then counsel contacted us and the answer had been filed. And because they had filed in a timely manner, the default was not an appropriate remedy.
Court crawling with Colin. Man, I missed that for the name of my channel. Court crawling with Colin. Second channel idea.
Your Honor, may I inquire?
So we set a scheduling order. Those are the dates. And you'll get a copy of this, Mr. Brown. And we'll get the scheduling order to both parties so that you know all the dates you're to be here. And if you get questions, answer them. If you have questions, send them. Okay?
All right.
Your Honor.
Yes, ma'am.
Does State Farm need to submit an order to be dismissed, or is that something?
Yes.
Yes.
No,
okay.
submit it.
Do you have that email again that I could submit it to? I can get it from the chat too, if it's already there.
All right, and Miss Lisa, if the two of you are done in the break room, if that's all you're here on, I just saw your chat, you're all set.
Thank you, Your Honor. Have a good day.
All right. That's it. That's all I got. This is over in about a minute. I think there's about a minute left of this, but that's it. I just looked to see who can potentially raid. I have Fight the Flat Earth and Artie. Those are the two that I have available to raid. So if you guys want me to raid either one of them, you just type it in the chat and we can raid one of them, or we can just call it a night. Up to you guys. But that's it for tonight. I do have a couple other clips that I have ready to go. So I could play a turtle clip, but here's the thing. Because courts are closed on Monday, I gotta use my court material this weekend sparingly. So no turtle clip tonight. I apologize. So I see you guys saying Artie. So we will go Artie. All right. You guys have a great weekend. I will see you guys tomorrow. Remember, no live stream tomorrow night. It is date night with Heather. I will most likely, it's always about a 50-50 chance whether or not I do a live on Saturday afternoon. But yeah, we'll see. We'll see what tomorrow brings. But yeah, if I don't see you tomorrow, I'll see you guys on Sunday. Enjoy your weekend. Don't do anything dumb. If you haven't done it already, please hit the like button. I would very much appreciate it. Thank you, everybody, for watching, for the likes, for the gifted memberships, the super chats, and the membership milestones. You all are awesome. And yeah, I will see you guys tomorrow. Until next time, bye.
All right, thank you. Bye. And I put that email in the chat for you, Miss Fields.
Thank you.
I bothered the court to put that back up. I didn't write
It should be, if you just like click on the chat, you should see it. It's in there.
Okay, thank you, Your Honor.
Yeah, civil@court23taylormi.gov. And Mr. Brown, you've got your next court date and we'll make sure we mail that all to you. Okay, sir?
Yeah, I see. I'm not gonna get anywhere with this.
All right, well, if Mr. Brown, I have to follow the court rules. I have to follow the law of the state of Michigan.
I respect that. I respect that, Your Honor, but it's not fair to me. I don't see, if he's insured by this insurance company, how is she dismissed? How are they dismissed from it?
Because that's not how
his
the
insurance company.
no-fault act works, sir. Mr. Brown, here's the problem with my role as the judge, is I cannot be your attorney and I cannot give you legal advice. It would be unethical for me to do that. So you need to contact an attorney that can explain to you the no-fault act, because I cannot do it.
All right, okay.
All right.
Oh, she is? I just looked. I already set it up to do Artie. We'll do Artie tonight. We'll raid Paisley. Man, I don't want to switch it now because I already told everyone I'm doing Artie. Yeah, we'll get Paisley. I raid her 2 or 3 times a week, so we can raid Artie tonight. But yeah, I am sorry I missed that. I didn't read down the list for the pending. I just looked to see who was live now. Anyways, have a great night, everybody. Later.
All right, sir.
Thank you.
Thank you.
Thank you. Have a good day.
Everyone have a good day.